We're good.
Okay, very good. Commissioners, welcome to the April ADRC Commission meeting. Thanks everybody for being here. Obviously, we have a quorum. And I appreciate all of the hard work that has been done. As we go through, I'll be praising each one of the committees for all of the work that's been done. And of course, we'll be talking about our new program manager, Dana Schmidt, and the outstanding work that she and her staff have done. But in any event, the meeting has been called to order. The first order of business is this: is there any corrections to the minutes of the January 19th quarterly meeting? All right, if there are no corrections to those minutes, I need a motion to approve the minutes as presented.
So move to approve. Second.
Okay, thank you, Mr. Rudolph, Mr. Hill, for a first and second. Those minutes have been approved. The second thing in the agenda, and again, Dana and staff, thank you so much for this detailed agenda. It helps us walk through so efficiently, is that if you've taken a look at the statistics I have, and probably there are two statistics that I just simply want to bring to your attention in comparative purposes, is that the first is that the total mediations resolved this quarter versus last year. This year it's 1513, it's now 1526. And then Dana, if you're going to go to the statistics, if you could go to how the mediation was conducted, I found this one not terribly surprising, but a bit surprising to me.
It surprised me quite a bit.
Pardon?
Whether they were conducted in person, yes.
Yeah. So
yes, I was surprised as well.
Yeah.
COVID.
So I went back. There were two surprises to me. I went back and compared, of course, the comparator is January 1 of 2021 to March 31st of 2021. And what we found was this, is that last year, video conferences were 31%. Now they're 21%. And of course, in person then was 41, and it's now 56%. I didn't think there would be that much of a movement based upon what I'd heard from a number of mediators, but certainly there is this movement back toward in person. I get it, but I did not think that it would be that significant of a shift since we're still sort of in the pandemic. And so, but literally we went from 31% video conference to 21%. And
that does not include the CMC data.
I didn't hear
That's
you.
Only, those are, that does not include community mediation center data. That is only data from people who self-reported.
That's right. And we all know that there is either underreporting or not reporting. And so this is simply based upon the reports that are submitted to the ADRC. And we know that there's a lot of reporting out there that does not get into our database here. And in any event, thank you, Dana, for that. And of course, the next thing on the item is to welcome Dana. And so Dana, welcome again. We're glad to have you here. Why don't you share with us and those of our fellow citizens that have joined us by YouTube, just a bit about yourself since this is your first meeting?
Well, I've been practicing law in some form or fashion for about 20 years. I started out with the Department of Children's Services as a state attorney. And then I was there for a few years, and then I went to work for the Davidson County Child Support Office. And I worked there till the end of the contract. And then I took a little break and was a stay-at-home mom, which was probably the hardest thing I'd done in my life up to that point. And then I was asked to come and run the parentage division at Davidson County Juvenile Court. And that encompassed a lot of what ADR wants to achieve, which is bring mediation and an alternative to litigation to families. And so I started there, and we developed what we call parental assistance court. We got our mediators Rule 31 trained. When I left, we had five staff with 3 trained as Rule 31 mediators, and then 2 more were on the list to take the training. And a big focus of the program was mediation. And in court mediations, we also worked with NCRC. A lot of what we did was the staff would do an interim parenting plan, and then we would refer to NCRC with Sarah's mediators, and then they would, try to attempt to work out a final order. And that's what I did for almost 7 years. And I loved it. And then when this position came open, I thought, what better way to try to access and implement what I know throughout the state. And so when the position came open, I jumped on it, and that's how I got here.
Yeah, well, great. Well, we're glad to have you. We're glad to have that background and that information that can help inform us as we move forward toward achieving access to justice, something that I know Justice Lee, who has joined us, good morning, Justice Lee, is very interested in. And so, well, that's a nice transition then, since you gave us your introduction. It's now the ALC staff report. And so I will turn it back to you then, Dana, and let you give us the report of the staff.
Okay. So for the 2022 renewals, this was, of course, I came at the end of February. And so I have to give a lot of credit to Stephanie Brake, because she guided me through this, and she is a superstar when it comes to the renewal process, absolute superstar. And as you all know, congratulations, she passed the bar exam. And now I've got to figure out how to keep her. But so the season is closed as of April 1st. As you can see, we had approximately 1,354 mediators, and out of that, 1,194 renewed, 88%. One of the things Stephanie and I did was we decided to do basically a 101 campaign. There, the last few days, right before March 31st, where we personally emailed from our work emails the remaining mediators who we had not received a renewal application from. And with that, we believe that helped us achieve the lowest number of lapses on recent record. So Stephanie ran the data and pulled out that we had a total of 160, give or take, that had not renewed, and that was the lowest amount of lapses we've had in quite some time. So I'm pretty proud of that. It was interesting by doing it that way. We got a lot of personal direct phone calls, and we're able to kind of get some information on what it was that was bogging down the renewal process for the mediators. And so some of it is really getting to understand the portal. We've gone straight to the portal in the last few years, and also another big part was the CME. A lot of the attorneys, I will tell you, they assumed their CLE would automatically load into our portal system, because a lot of the CLEs, the provider sends that to the CLE commission, and we're not there yet. And so that was one thing we talked through. And the good thing was they had taken it, the requisite CME, they didn't understand it hadn't posted. And so we walked them through that. So that's one thing we did learn. And then Steve, we also have update on the medical debt ODR pilot update. We have finished phase 1, and there's a fabulous report. It's exhibit number 2, attachment number 2. It's approximately 32 pages, and it gives an outline on the beginning to where the end of phase 1. And I think Steve can add to this too, but I think from the AOC standpoint, phase 1 was a success. Now, where does that leave us? Just last week, we have a standing ODR committee meeting every Thursday. And so now we have moved into, what does phase 2 look like? And where do we want to grow ODR? Steve has suggested that we start focusing on Memphis. And so that's what we're doing now, is building out phase 2 and what it's going to look like for the rest of Tennessee.
I attached my mediators report. The interesting thing, fellow commissioners and fellow mediators, is that now mediations are taking place asynchronously via text. And quite candidly, I didn't see that sort of feature coming. And so as a result, then it is being asynchronous via text. And so, okay, we'll come back to the asynchronous training later on then, Dana. That's okay with you.
Okay.
We'll get to that.
Mhm.
And so any questions, any discussion about either the renewals or the medical debt? Okay, then let's turn to the committee reports. You know, I've been on the commission now for several years. Typically, there might be 2 or 3 committees that had some work that had to be done. This time, I think almost, not all, but almost all the committees were engaged with certain tasks that they had to accomplish. And so again, that committee work has just been incredible. And so I'm going to turn now to the committees. And Lori Reed, I'm going to turn it back to you on the new Rule 31 Mediator applications.
Thank you, Steve. Good morning, everyone. I hope everyone has had a chance to look at the applicants, and obviously it goes without saying the work that the staff completes for us, following up with people who need additional documents for their applications and getting it to this point is phenomenal. So what I'd like to do is go ahead and unless somebody has a question or a comment, I would like to make a motion for the 14, let's see. We have 160923, 160216, 161008, 160982. 160916 was approved by our committee pending the waiver, training waiver request, and that has passed by the training committee. So I'm going to include that 160916 in my motion to approve. The next one is 160985, 161026, 160966, 160988, 160486. All of those, excuse me, two last ones, 161007 and 160961. Our committee has voted to approve all of those applications, and that is my motion.
Your second?
Second.
Okay.
Is there any discussion? All those in favor of approving those listed that I previously listed for approval of their applications, say aye.
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 Opposed? Anyone opposed? Okay, thank you. We need to specifically discuss number 160921. The application was deficient with a work history section. This is a paralegal. The documents are in your packet. Since he does not have a graduate degree, he has to have 120 months of work history that complies with the requirements of Rule 31, and the committee's belief is that he does not meet that, his work history does not meet that requirement, and also that he could not, if we deferred it for a year, he could not make that up within the year. So we have voted we are recommending that be denied. So I move that we deny number 160921. Is there a second?
Second.
All those in favor of the motion, say aye.
Aye.
Anyone opposed? Thank you. The next issue is a very unfortunate situation that, wait a minute, I think I have one more on that list.
Mm-mm.
Okay,
Yeah, you're correct.
okay.
Lori. Uh-huh.
So on number 160981, that was pending. We approved that application pending the training waiver requests. And it's my understanding that the training waiver requests, the training committee did not approve the training waiver. So we would then be, do we continue to defer that, or is it denied? I'm not sure
Madam
which
Chair,
the training committee wants.
The chair of the Training and Education Committee will give their recommendation for that one.
Okay.
So you don't have to
Okay,
do that
so
one.
it just continues to be deferred until the training committee makes their, has their motion, right?
Yes, ma'am.
Okay. Okay, thank you. The next issue has to do with a mediator whose listing lapsed. He appealed that, and after a long discussion about what seems to be a little bit of a harsh penalty for not doing what you're supposed to do, we felt it was important to follow the Rule 31 guidelines and not make exceptions, because then we would be in a real mess. So the appeal request from a lapsed mediator, we're recommending that it be denied. I'll move that I was going to abstain on this. If someone else would make a motion to deny that request, the appeal request, please, if there's a motion.
So moved.
Is there a second?
Second.
All those in favor, is there any discussion? All those in favor of denying the appeal request, say aye.
Aye.
Anyone opposed?
No.
I believe the motion passes. Thank you for your participation on these important matters.
Very good. Thank you, Lori Reed. I appreciate it and the hard work that the committee does, and I know along with the staff. And so let me turn to Marcus Rudolph. Marcus, you're the chair of the Training and Education Committee. Let's turn to your report.
Thank you, Steve. Good morning, everyone. My name is Marcus Rudolph. It's an honor to be in front of you guys again to make a report in regards to the Training and Education Committee. There are several items I will go over, but at first, I'd just like to thank a couple people, the ALC staff, along with Ann Louise, Dana, and Stephanie, the new state attorney, the new person who's passed the bar. Congratulations, Stephanie. But thank you for all the work that you have done for every single committee and for the board as a whole. Your work and diligence is very appreciated. And secondarily, I'd like to thank the other members of the Training and Education Committee. That's Mr. Charles Hill and Miss Linda Seeley. They're outstanding people hardworking. Their experience is fantastic, and I really do appreciate everything they've done. So being that said, I'll go right into the items that I'll go into. The first item is the training providers, giving an update. All 17 providers from 2021 requested recertification for 2022. And after confirming that none of their programs made any substantial changes, all of 17 providers have been approved. And these providers are all in person. There's no process of remote training as of yet. But we do appreciate the diligence of the AOC staff to looking in that matter and then providing that information to the committee. Second item is the training waivers, the training waiver requests. We have two of note. The first applicant is applicant 160916. If you're following along, committee members, that is attachment number 8 that was sent out. Applicant is applying for general civil listing and is approved, active, and in good standing as a mediator for the state of Georgia. And that has been confirmed by the state of Georgia. That information from Dana and the AOC staff was presented to the Training and Education Committee last week. And the committee, after review, recommends approval of this applicant based off reciprocity. So I make a motion on behalf of the committee for 160916 to be approved by the board. Is there a second?
Second.
Thank you. All parties in favor of 160916 to be approved, all say aye, please.
Aye.
Aye.
Any nays? So moved. The second applicant, 160981, which is attachment number 9. Applicant took a non-pre-approved course for general civil and family listing from the state of Texas. Applicant also provided a resume for consideration of the domestic violence training waiver. The programs manager, Ms. Schmidt, provided this information to the Training and Education Committee. Programs manager believes that both trainings have not met the substantial equivalent standard. And so therefore, our committee recommends deferral for this applicant until questions presented to the training provider are answered and reviewed. So I make a motion for 160981 to be deferred. Is there a second?
Second.
Thank you. All parties in favor of 160981 to be deferred until we gather more information, please say aye.
Aye.
Any nays? All right, so moved. All right, the third item. This is in regards to the annual ADRC workshop. This is for 2022. We, as the Training Education Committee, came up to the decision that we were going to set the date for the workshop on October 14th of this year. I know that the AOC staff had received some inquiries from different people as far as different dates. October 14th works for us to coincide with Lipscomb University, who's our host. They'll be also on fall break. So that means a little bit more space, more resource for us. That's why we had made that decision. The event will be offered in a hybrid format. So that's in-person and remote training until there is something that would make it hard for us not to go hybrid. That is the way that we will proceed moving forward. The committee will also will review survey results to continue gathering topic and speaker ideas. So I would say to anybody listening out there, if you have any topics that you would like to be heard or any speakers that you would like to recommend, please send that information to the AOC staff. They'll sort that out and they'll present that information to the Training Education Committee so we can make logical decisions moving forward of how to make this workshop a success. So fourth item of topic, and I also like to ask Mr. Charles Hill to step in after I'm done reading this to provide a little bit more context. The committee is considering revision to curriculum requirements in regards to domestic violence training. The committee has met with 4 approved providers and others from the state of Michigan and the state of Ohio, as well as examine training in effect in states of Maine and Georgia. The committee will also soon canvass the Academy of Professional Family Mediators for the input. Mr. Hill, would you like to provide a little bit more context in regards to that?
Sure. We've been able to collect a considerable amount of suggestions and ideas about how the training might be improved to reflect more on what mediators need as opposed to some of the other items that are involved in that course. And we expect to have the results from the Academy of Professional Family Mediators, who Linda Seeley was implementing and helping to gather some thoughts from those mediators. And we expect to have a set of suggested revisions before this committee by our July meeting.
Thank you, Mr. Hill. And I would be remiss if I did not say thank you to you, Mr. Hill, and Ms. Seeley for all the background work that you have done on this particular topic. It's been incredible, the amount of time and effort that you both have put towards this. So I do appreciate that. Thank you. Lastly, on my report, I want to just give an update on the pilot program requirements, and I'll read this information, and then I would like our chair, Steve Shields, to step in and state a few words of feedback in regards to this. Ms. Brake or Dana, can you pull up the old language in paragraph number 5 in regards to what we're talking about here? If you could pull that up real quick, if that's possible. All right. And if okay, and if some,
Just a second. We'll get it. Give us just a second.
no problem. Yeah. While they're doing that, I just want to state that we have put in some time and effort in regards to figuring out what's the best way to present the methodology language in regards to this particular situation. And I think we have, as of last week, come to an accord of how we want to present the language. So I appreciate Mr. Shields giving his feedback last week in regards to this. Have we found it yet?
We're pulling it up now.
All right, beautiful. All right, so, and I'm reading from my phone, so I apologize if I'm squinting, but it basically states, trainer may not use in excess of 3 hours of pre-recorded material. This is in regards to what Steve was talking about earlier in regards to asynchronous learning. After, I would say, almost a year of talking about this and figuring out what the best way to present this information, the committee has voted to replace the requirement in paragraph number 5 with the following: 8 hours of pre-recorded / written assignment material with a total of 3 hours that may be asynchronous. So I think that we came to accord in regards to language like that. Steve, do you want to expound on that just a little bit further?
Yeah, well, the original paragraph 5, it said 3 hours of pre-recorded. The question then they started being posed was, is that asynchronous or synchronous? And so then there were a number of schools of thought, and there still are different schools of thought. One is there ought not to be any asynchronous. Others say there ought to be a considerable amount of asynchronous. I actually attended Quinnipiac's 40-hour training, in which they had 12 hours of asynchronous and 28 hours of synchronous. Of the 28 hours of synchronous, they had another almost 6.5 hours. I thought that was way too much. I recommended to the committee then, based upon my conversations with other individuals in CMCs, and I don't feel wed to this, but after those conversations, I recommended a total of 8 hours, 3 hours of which could be asynchronous. I'm not suggesting that we prescribe to a trainer what goes in those 3 hours, but to give you an idea, what I did was to sort of time then simply a discussion of what is mediation versus arbitration, negotiations, etc. Then I have an hour and 20-minute then mediation video, and then reading through Rule 31 and the pamphlet Pod A Squared. And when I timed all of that together, I came up with 3 hours. What I found from the Quinnipiac attendees was that they felt it was very helpful to walk into the training having a good understanding and actually seeing a mediation before they actually got to the training itself. And then, of course, in talking with other CMC individuals and others, the idea was that, well, we do have videos. Some of you may have seen the recent TAPM training in which there were a number of videos that were shown. And so this is sort of how I suggested, how I arrived at. I realize there are different schools of thought on this, but that's how I arrived at the 8 hours with 3 hours of synchronous. And again, we're not, the committee's not prescribing what needs to go into the 3 hours or the 8 hours. They're simply saying that you can't have 30 hours of asynchronous training where somebody sits at home and just watches stuff. So that's the backdrop. And there's material that you can see that I included, how Quinnipiac then made sure that the 3 hours asynchronous was actually accomplished. The key then was that until you finished all of the asynchronous training, unless you finished all the asynchronous training, you would not get a certificate from them.
Chair, may I make a comment?
Yes.
Steve, as I recall, you were helpful in describing how what you're intending is that they can't use more than 3 and more than 8 to count toward the 40-hour or the training. They could use more, but not to count toward that. I would hope that we could wordsmith this in such a way, Steph and Dana, that it's clear that trainers could use more, that they simply can't count more than 3 and 8 toward the qualification.
Chuck, do you think that's necessary? I mean, obviously it says at least a 4-hour training when you take a look at the rule. And I agree with you. I may in fact have more, asynchronous or whatever than that the training would be more than 40.
Well, I was reacting to the way it was written in the original, which said you cannot use more than those hours. It didn't specify that.
Okay. What's your suggestion?
Oh, I don't know. I just think we can wordsmith something that will I don't want to tie the trainer's hands beyond, the limitation of how much can count towards the satisfying, the hours of the course. But they can use more if they want to. I'm sure we can come up with some language that will clarify that.
Yeah, sure. Okay. And so, Chair, how do you want to proceed then? I don't want to.
Well, I think that we can figure that out later. My question is in regards to this is, do we need to make a vote in regards to this right now, or we can just hold off in rewording everything and then present it to a later situation?
Well, I think that's up to whatever other commissioners think. I'm ready to, that there's been so much interest in this. I'm ready to have a vote on it.
Okay.
And so certainly, the staff can come up with some sort of explanatory thing that this is not a total limit. I think the key is to change the requirement. And if staff wants to add some sort of explanatory statement to explain it, then I think the staff can come up with that subject to your approval. And so my thought would be to approve the change in the rule itself and then ask the committee to come up with some explanatory explanation that reflects then Chuck Hill's concern.
Okay. All right. Well, thank you, Steve, for that clarification. Well, then I put it to the committee. I make, is there a motion to approve the change in the requirement that we just presented to everybody?
Motion to approve.
So moved.
Okay. All parties in favor of the change language in paragraph 5, please say aye.
Aye.
Aye. Aye.
Any nays?
I second also, by the way.
Okay. Any nays? Okay, so moved. Thank you, everybody. And that is my report.
Okay, thank you, Marcus. Of course, the staff will make the change in that virtual requirement, and we'll get it out to all of the trainers along with some explanatory language that I'm sure you'll share with Marcus Rudolph and his committee. And so thank you, Marcus. It was a lot of work. And so next then, Sarah Fiegel, the Pro Bono Mediation Advisory Joint Committee report.
Thank you, Mr. Chairman. We have 2 projects we are working on. We have nothing to vote on currently, but the major areas of investigation now are, firstly, we are looking at standards that we could clarify what it takes to be considered a community mediation center in Tennessee. And this has come up because we received a request by someone who purports to be doing community mediation and wanted to be listed on the AOC website. Recognizing that any listing on the AOC website can be understood as endorsement, we thought that we really ought to take a look at what it means, right, to list centers. What is it that we are suggesting or not suggesting, and what constitutes a mediation center? There are various precedents. If anyone's interested in joining this discussion, please do. The second project at the moment, we are discussing the status of, the ongoing problem that community mediation data does not make it into and therefore become combined with other mediation data that's collected by the AOC. So we are working on putting together a comprehensive report by the CMCs that can be presented to the ADRC and the AOC collectively, so we can then begin to create the goal is to create a more comprehensive report of the state of mediation in Tennessee, which then justifies other initiatives to expand and grow and seek support. I guess we've been working on this for quite some time and realized that it's probably going to be most efficient if the CMCs join forces together and then come as an already collected pool of data to the ADRC. We should have that. I am promised all the data by May 30th. I will have it all processed by, maybe June 15th. And so somewhere around then at the next meeting, we'll be able to make a report. And that's all we have.
Okay, thank you, Sarah. Very good. Dana, I'm going to turn it to you for the Grievance Committee.
For this quarter, we had 1 new filing. When we received it, we reviewed the timestamp on it and the date that we received it, and it was time barred. So it was beyond the required time to submit the grievance. And that was the only one. And so it was closed.
Okay, all right. Thank you. Thank you, Dana. And so Cindy, we can't see you, but we can certainly listen to your report. Cindy, are you there? Who's on Cindy's committee then? Anybody on the committee with Cindy?
Sure. I'll just jump in. We, as a committee, we're revamping the ADR newsletter. Dana just produced Magic, and you've all seen our first special We're Back newsletter. It was a special edition, and it was sent out April 18th to all active mediators. And we have assigned out among the committee responsibilities for each of the newsletters. We're hoping that that will ensure a variety of input. And I think that's pretty much it. We're pretty excited. We're excited about it.
Yeah, and the way we designed the newsletter, each member of the committee is going to take a quarter for the newsletter and have a special article. And then, of course, as we get to the end of the year, we will be focusing on renewal status. And then that kind of falls into the renewal efforts. Steph designs what we call MailChimp campaigns, and she sends them out to all of the active mediators who we have listed with their email addresses. And so, as you can see, this was our email campaign to make our mediators aware of the deadlines. And then, of course, we ended it with our direct outreach. So we will always continue the MailChimp, and we're going to talk about the outreach. Probably we will do, since the actual deadline is December 31st, we're going to start the outreach probably in November this year. And hopefully we won't be very busy at the end of March.
Dana, let me chime in just a little bit here. I'm going to link back to the individual who in fact requested that, even though he had missed a deadline, that he asked for a reprieve or a waiver or something for that. And of course, then what the committee said was, well, wait a minute, the deadline's the deadline. And so how many individuals, and maybe you've got this information, how many individuals missed a deadline with a resulting lapse in their Rule 31 listing? Do you have to be carrying that in your head?
We had 160 who chose not to renew or inadvertently did not renew. I mean, I communicated with one mediator who was like, I'm going to fully retire and enjoy my grandchildren. And so that one I had direct communication with, but we had 160 out of approximately 1,400.
Okay. Out of that number, how many complained about the deadline, that they didn't know that there was a lapse? Was there just a handful? And I say this, fellow commissioners, because somebody indicated that they thought this penalty of lapsing was very harsh. I think you heard that from one of the committee members earlier, that the person's comment was, simply because I missed a deadline, it ought not lapse. And you can imagine they're probably analogizing to the legal profession, in which there's a grace period. How many fell within that category of, hey, wait a minute, I can't believe it's lapsed and this. Did you have many of those?
Directly that I had communication with, we had 3. They knew the deadline, and it was just, I missed it. And I just think that a lapse is unfair. But they didn't have an issue with the initial deadline, the fact that it's basically extended 3 months, any of that. It was just that the consensus was it's lapses. The idea of lapsing and not being able to renew or reinstate was a little strict.
So,
that was it.
Yeah. So what I understand is you're going to have reminders, and then of course you're going to use the newsletter as also another vehicle to how to maintain your listing. And so we should certainly be put on notice.
Chair, if I may.
Yes.
I'm not prepared to put something on the table at this particular meeting, but I think a rather simple resolution to this issue that I would support is the notion of changing the language in the rule to say, at the at the discretion of the committee, you may have to retake the training so that we have some discretion. So someone who has lapsed and has not been active and has just, walked off and disappeared for the last 5 or 6 years, yeah, they might have to take the retraining. Someone like the case that we had where they did 2 or 3 mediations per week during that interim period, we might at our discretion say, okay, you have some penalty, but you don't have to retake the training. I think discretion, I understand the concern about not having a precedence, but I think if people meet the same exceptions, then I'm not concerned about a precedent. I think we can deal with that. We're intelligent enough to deal with that, and we get the big bucks to make those kind of discretionary decisions. But I don't want to put that on the table now.
Oh, I'm going to ask then that the Training and Education Committee then address this issue, but before they have a meeting to address or with enough time to maybe, I need to think through, communicate with the other commissioners and see what their thoughts are and to get their input unless they want to get their input now. Since you're not putting anything on the table, let me return it to the Training and Education Committee, I think is the proper place, along with an opportunity then for other commissioners to even comment before the commission meeting next time would be my thought. Is that okay with you, Chuck Hill?
That makes sense. And I have one other question, if I could.
Sure.
And that goes back to Sarah and your report about the inclusion of data from the community mediation centers. This is kind of a stupid question, but I'm sure you guys are considering the issue of whether or not individual mediators would report as well as the center reporting on behalf, so we don't double count. I'm sure that's in your thoughts, right? Okay, that's it.
Okay, thank you, Chuck Hill. I appreciate it very much. Let's turn to Rich. Let's turn to you and the Ethics Advisory Committee. I know you had a couple of requests.
Yes, the motto of our committee over the last quarter has been activity resulting in inactivity. We had 2 requests for ethics advisory opinions. Neither of those involved Rule 31 mediations, and one of them, at least, maybe both, did not involve requests from Rule 31 mediators dealing with mediations in which they had been involved. One was a removal from state court to federal court. So as a committee, we looked at Rule 31, specifically Section 9D as in Delta, and that's sort of our enabling rule. In other words, that sets forth the purview. What is our authority? When do we issue opinions? And we reached the conclusion, based upon the language of that rule, that the Ethics Committee will render ethics opinions requested by Rule 31 mediators involving Rule 31 mediations. And the language is pretty clear in that regard. So based upon that enabling legislation, as it were, the committee decided that the 2 requests that were submitted to us fell outside the scope of what I'll call our authority. And the letter was sent in the first one explaining that, and a letter will go out with regard to the second request for an ethics opinion, setting forth that thank you for your request, but it falls outside the purview of the committee.
Okay, thank you, Rick. Does anybody have any questions about that? I think the language, as you've said, was very clear. It just simply fell out the scope of our responsibility, Rick.
Right.
Yeah. And so, as I indicated thank you, Rick. At the very beginning, I indicated to you almost every committee had something to report on this time, except Betsy. There's been nothing before the Rule and Policy Review Committee, so there's no report. Is that correct?
That's correct.
Okay, very good. Thank you, Betsy. Wow, it is 11:25. We've moved through this meeting very efficiently. A big reason for moving through it so efficiently is the great staff that we have. Dana, welcome aboard again. Thank you for all your hard work. Stephanie, and of course, the others on the staff. You guys always do a remarkable, remarkable job in assisting us. And of course, as you can tell then, that the commissioners have done a great deal of work between the last meeting and this meeting. A good deal of work lies ahead of us in terms of promoting mediation and promoting access to justice. Again, the exciting program on med debt to help our fellow citizens. And so we've got some exciting things coming up. I think, Dana, you have here a new Rule 31 application deadline is June 7th. Our next meeting is July 19th. At 10:30. And so I appreciate all the really hard work and intelligence that you have brought to our mediation program here in the state of Tennessee. And of course, as always, Justice Lee, thank you for your support. We couldn't do a lot of this without, obviously, the support that you give to the commission. Does anybody have any other closing comments? I'm going to have a motion to adjourn. Is there a motion to adjourn?
So moved.
Okay, there's a motion. All those in favor say aye.